varies, unlike for the state universities where the governors are the standard chancellors of all the state universities. Okay, let's move on now. Begin our discussion with 5 questions for today. Yes, sure, Anand. How many of you did not see incorrect? Please, emotional aspirants, every day, same story. With reference to DPC, consider the following statements. 74th Amendment Act provides for the establishment of DPC. It's absolutely correct. It has representation from both rural and urban population. Of course, it's correct. Four-fifth members are nominated. No. These 4/5 are elected by and from amongst the members of panchayats, municipalities, etc. Right? So 2 is wrong. This is 1/5. So incorrect. Only 1 is incorrect. A. Only 1 is the answer. Okay. Moving on to the next question. 92. Wrong. Yes, Rajasthan became the first state in independent India in which the Panchayati Raj institution was established. Is correct. Are we clear on this? Everybody. So, answer here is only 1. Moving on to the, there's no dual plea is going to decide on this. So this is actually wrong. Are we clear? I had specifically pointed this out that for the municipalities, this is a big point of difference, that nothing is mentioned insofar as the reservation amongst chairpersons is concerned. Divya, LSG, local self-governance, madam, what are you doing? Okay. Moving on to the 4th question. Assembly people, not small kids. They're not a part of Gram Sabha. Last question for the day. Is actually correct. In case of money bills, Raj Sabha is subordinate to the Lok Sabha and the councils to the assemblies is correct. So C, both 1 and 2 are correct. That's it. We are done with the questions for the day. Okay. So we are discussing judiciary. I had explained the collegium as well as the qualification, I believe. Right? Yes or no? Was the qualification explained? Now we'll move to discuss the removal of the judges in our courts. But before that, of course, let's not forget the leaderboard. 6 toppers for today. Anita Roberts. One more thing now, since all of you are here, again, I'll repeat this. Tomorrow is a holiday on the account of Ganesh Chaturthi. Yes, it's very, very important to read. Seen the GS paper 2, which was asked just yesterday and day before yesterday. And I hope that the questions you saw would instill a sense of confidence. Now, I don't want to boast that, see, I told you questions from activism, questions from panchayats will come. I think every informed faculty would tell you the same. That does not really matter. But try to solve. See, we had 3 questions which you could have solved directly as of now, and 2 more questions that you can solve after judiciary, and 1 more question or 2 more questions which you can solve after discussing fundamental rights. So if you go through the paper, you will find a question on parliamentary committees. We have discussed that in detail. If you go through the paper, you'll find a question on panchayats. You have 30-40 points on panchayats to write. If you go to the question, you'll find a question on the presiding officers, right? Now, if you go through the paper, you'll also find questions on NALSA and independence of judiciary, which we covered separately in our slides. Sufficient information. Then there's a question on, as I have said, that UPSC tries to link gender issues with polity or social justice or governance. That's what they have done here also. They have linked it to women's rights. So that can only be solved after reading fundamental rights. And one more question was directly on Article 21, that also after covering fundamental rights. One more question was on President's rule. Again, we have been covering that since a long period of time. Direct question from S.R. Bommai judgment, which was actually mentioned also since 1990s. So largely all the questions were covered in the PPT. So maybe the paper was relatively on the easier side. To be very frank, it was easy to medium, not at all difficult. Rishu will discuss NALSA under judiciary. If you go and look at the previous videos also, we have discussed in detail on NALSA. It is not that I'll be making any new change in the PPT. This one is the exact same PPT that I am using for the weekend class, where we had discussed NALSA earlier only. So all topics have been covered. Okay. Now, tomorrow, please download the paper and write all the answers that you possibly know as far as the paper is concerned. Okay, 3 questions. Let's come back now to judiciary, our point of discussion. My reason for telling you this is because I just want you to have this sense of confidence that if you mug up all the information on the PPTs, all the points, supplement it with your monthly magazine, Yojana Kurukshetra, trust me, you're going to score very good marks in your main examination. This is bound to be the case, both for prelims and for mains. The only point is, are you going to put in the effort or not? Okay. Now, coming back to our discussion, process of removal of our great honorable judges of the Supreme Court and the High Courts. This process is mentioned under Article 124 and also 125. So Article 124 clause 4, Article 124 clause 4 and clause 5, not Article 125 clause 5. So Article 124 clause 4 says the ground for removal. What's the ground? Reason for removal. Why are we removing the judge? That is misbehavior or incapacity. Now, what is misbehavior? What is incapacity? It is not defined in the Constitution. We don't really know what these words would mean. It depends on the allegation. Okay. So that is there. Abhishek, definition of misbehavior. I think I only must have mentioned somewhere. Misbehavior's definition is not mentioned categorically. It is partially mentioned under Article 317, Clause 4, for a separate issue. That is with respect to UPSC members' removal. Otherwise, misbehavior and incapacity categorically are not defined with respect to removal of judges. Clear? Now, how will we remove the judges? So the judges are to be removed by voting in the parliament. Parliament can remove the judges of Supreme Court. And what have I mentioned here? Parliament can remove the judges of Supreme Court and High Courts. This is mentioned under Article 218, article not really important. But my point is that the procedure, the manner, the ground to remove the Supreme Court judge and the High Court judge is exactly the same. Are we clear? Exact same process, exact same reason, exact same person, exact same voting requirement. Okay. So what's the voting requirement? Parliament will vote through a special majority, which is what? A combination. 2/3 present and voting, more than 50% of the total strength or total membership. This is a special majority required to what? Remove the president, remove the judges. Now, one more thing. How to remove the judge? I mean, there should be a procedure. What's the procedure? Manner means procedure. So, you see this word manner, it is the procedure. So, the Constitution says, Article 124, Clause 5 says that Parliament by law to decide the procedure. Okay? And Parliament has made a law and has decided a procedure. And what's the procedure? This is the procedure. This is the law. The Judges Inquiry Act 1968. This is the law which mentions the detailed procedure which will be used to remove the judges. Now, one more point. We have discussed also in the past that there is somebody who is removed in the same manner as a High Court judge. Can you tell me, just on a side note, same removal for certain dignitaries are removed in the same manner? Attorney General? Advocate General? What are you saying, guys? Very good. So at least some of you are right. State Election Commissioner, SEC. Article 243, capital K. State election commissioners are removed in the same manner. Also, Chief Election Commissioner of India is removed in the same manner. Also, the CAG. They are all removed in the same manner. Are we clear? Just mentioning this point here, though it has got no relationship, but I am mentioning this so that you know that this is also a fact. Now, what is a procedure? How to remove judges? This is a procedure mentioned. Let me explain one by one, very easy to understand. Simple. Step 1. In case you want to remove a judge of the Supreme Court or the High Court, this will start in the Parliament only. Lok Sabha or Rajya Sabha. Does not matter. Are we clear? Does not matter. Now, if you want to start this process in the Lok Sabha, 100 MPs have to sign. 100, 100. 100 MPs have to give a notice in writing to the presiding officer, giving reasons that we want to remove the person because of this reason. Or 50 MPs in the Rajya Sabha have to give a notice in writing to the presiding officer that we want to remove the judge. This is the reason. This is the allegation. Now, when the presiding officer gets the notice, he may choose to reject the notice, saying, useless, nonsense. What is this? Wasting my time. He can also accept the notice. So that's check number 1, actually. The presiding officer has full authority in rejecting the notice. This has happened in the case of this judge Deepak Mishra. He was a former CJI. When members gave this notice for removal in Rajya Sabha, the vice president, the chairman of Rajya Sabha, turned it down, saying nonsense, remove it. So he did not accept the notice. Now, if the notice is accepted, may accept or reject. If it is accepted, then a committee is formed. This is the inquiry committee actually. This committee So when we say inquiry, this is that inquiry committee, which will comprise of 3 people. The judge of the Supreme Court, normally the CJI, one Chief Justice of a High Court, and a distinguished or eminent jurist, somebody who's an expert in the field of law. Normally, this would be a person who would be, say, retired Supreme Court judge. I think we have, Bhuvnesh, calm down, calm down. Retirement age of judge. We have discussed this earlier also. No revisions happening. 65 for Supreme Court. And distinguished jurist, we have discussed this earlier also. Who is a jurist? Jurist is a person who is an expert in the field of law. Okay. Now, this inquiry committee's task is what? The task is to look into the allegation and find out whether that allegation is true or false. Now, if the allegation is false, right? If the committee finds judge not guilty, then the process is over. End of process. If not guilty, process ends or matter ends. But if the judge is found guilty, please, they will not be removed. Still, voting is required. Voting takes place in both the houses separately. Voting takes place in both the houses separately. Now, if it is approved by majority of members, that is a special majority, and by both the houses separately, then the person is removed. And the president has no veto power here. The president must sign in the same session. Must give assent in the same parliamentary session. Clear? This is how judges are removed in the country. Such a difficult procedure. And the procedure is so complicated and difficult that not a single judge has ever been removed. I mean, we have seen cases where judges have been found to be guilty, have been involved in misbehavior, like say acts of corruption, could not be removed. Okay. A very famous case is of Justice V. Ramaswamy, who was a Supreme Court judge. And the allegation was that when he was the Supreme Court, when he was the Chief Justice of Punjab and Haryana High Court, then what happened? Then he had spent some money on beautifying his official residence. Just like one CM of a state is spending money or has spent money to beautify his official residence. Similarly, anyway, when the matter was raised, it was accepted in Lok Sabha. When the matter was brought in front of inquiry committee, they also found the allegation to be true. They gave the recommendation, yes, remove him. Voting started in the Lok Sabha, but sadly in the Lok Sabha, Congress walked out and the numbers could not be achieved and hence could not be removed. Okay. One more judge, or rather, see, these inquiry committees keep on happening. JB Pardiwala, who is a Supreme Court judge right now, very popular in Gujarat High Court because he was very prone to giving judgments in favor of environmental concerns, right? So right now he's judge of the Supreme Court. So once in a matter which was being discussed, presided over by him, he was looking into a CBI corruption case, and while giving the judgment, he made some statements on reservation policy, which he had to take back later on, because when he made a negative statement on reservation policy, saying that the country is suffering because of two things: corruption, right? And what? Reservation. So that's what he mentioned in the court. Now, reservation is a policy which is mentioned in the constitution. You are a judge and you are not upholding the uh, tenets of the constitution. Immediately in the Rajya Sabha, 58 MPs gave a notice that remove him. But I think matter was settled when Justice Padiwala took back his statement, and hence the matter was closed. Then we had cases of S.K. Gangale, the MP High Court judge, against whom there was this issue of sexual harassment allegation by a district court judge, or Justice Nagarjun Reddy from the Andhra Pradesh High Court, against whom the allegation that he used to make caste-based remarks, slurs in the court only, but nothing could be proved, right, with respect to the remarks that he made. So the inquiry committee did not find the merit in the allegation. But the most interesting cases have been of Justice Soumitra Sen and P.D. Dinakaran. Justice Soumitra Sen actually said that, or rather, in his case, the allegation was that he had siphoned off 33 lakh rupees in 1983. He was a judge of the Calcutta High Court. And when this allegation was raised, MPs in Rajya Sabha gave a notice. The notice was accepted. Supreme Court of the inquiry committee found the allegation to be true. Voting started. It was passed in Rajya Sabha. It went to Lok Sabha, right? And then, before the Lok Sabha could vote on it, he resigned, stating this moral argument that, see, if the Rajya Sabha has found me guilty, I'll resign. At the same time, one more judge from Sikkim High Court, Justice P.D. Dinakaran, he also resigned. There were allegations against him of land grabbing. Anyway, both of them resigned in 2011. Somebody had filed an RTI later on this topic only, that these two judges, Soumitra Sen and P.D. Dinakaran, are they getting a pension? So government said, yes, of course, they are getting a pension because they have resigned, not been removed. So these judges resigned because they had the pension at the back of their mind, right? Anyway, so far, not a single judge has been removed at all. And just to add one point here, all these judges, except V. Ramaswamy, have been the product of the great collegium system. Anyway, I think that has got nothing to do with the wrong deed, but still just reminding you that yes, collegium does make a mistake. Okay. Does CJ allow? No. Center. Satyapal, Congress always support corruption. Oh, I can't make all these statements. Don't make me read all these things, right? What if somebody cuts this only and starts playing everywhere that I have made a statement? Okay. I don't know whether any party is corrupt or not. If the court finds anybody guilty, then I can make the statement. Otherwise, come on, innocent till proven guilty, right? So this is the procedure of removal of the judges. Solve this question. Very simple, very easy. Lakshya, both houses have to pass it separately. Sibam, special session, nothing, sir. Normally we have 3 sessions. If any session is held beyond these 3 sessions, we call it a special session. Simple. Shahid, anyhow, the initiation of removal in either Lok Sabha or Rajya Sabha. Akash. CJI is the person who allocates cases to other judges. That's it. That's the only special power. And of course, veto power. The motion to impeach a judge cannot be rejected by the speaker. Yes, it can be rejected. Right? May not. One is wrong. Good old days of elimination. 3 has to be correct. Don't mark 3 as wrong. The details of the process of impeachment of judges of the Supreme Court are given in the Judges Inquiry Act. The Constitution of India defines and gives detail of what constitutes incapacity. Of course not. Wrong. If the motion of impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of total membership of that house and by not less than 2/3 of the total members of the house present and voting. This is just the special majority written in an elaborate fashion. Right? So, C is the right answer. Now, some of you are raising this question that, sir, we are using the word impeach. Why is it being used? UPSC is UPSC, right? And no, to be fair, impeachment is actually an English word also, which means the procedure to remove high functionaries through voting in the parliament, right? The origin of impeachment comes from the British Parliament, the Bill of Attaiндers, right? The famous impeachment of Warren Hastings. If you study a modern India, Edmund Burke moved the motion to impeach Warren Hastings. So that's the logic. But yes, we should not use these words so casually. But it's UPSC. What can you do, right? So impeachment in the Indian Constitution is used only for the president, nobody else. But sadly, here it has been used. It's okay, no problem. Now moving on to the salary and oath. Oh, tell me, the salary of the judges of the Supreme Court and High Courts, where is that mentioned? Which schedule? Okay, great. Some of you are still mentioning the third schedule. Why? Salary in schedule 2, oath in schedule 3. Okay, so salary schedule 2 also under article 125 schedule 2. Oath, yes, oath is mentioned under schedule 3 along with the oath of the High Court judges and also the President of India. Yes or no? What happened? No response. What? Yes. Nonsense. Last time also made the same mistake. Not the president, right? President's oath is not mentioned in schedule 3. Okay. Anyway, now apart from this, as far as the salary is concerned, there's also a law called Supreme Court Salaries and Conditions of Service Act. Salaries and Conditions of Act of 1958. Clear? We know the salary. The salary of the CGI is 2.85 lakhs per month and the other judges is 2.5 lakhs per month. Okay, that's the law. Now, please pay attention to what I'm going to tell you. Salaries, pension of Supreme Court judges. Charged on CFI. Clear? Pension of High Court judges. Charged on CFI. Salary of High Court judges. Charged on CFS. Are you able to understand this point? The salary of the High Court judge is paid by the state government, but the pension of the High Court judge is paid by the center. Clear? Are we all clear on this? Okay. Now, of course, the salaries shall not be reduced to the disadvantage. Will not be reduced to disadvantage. Okay. Now, one more very important point. When it comes to the retired Supreme Court judges, right, or any person who has been a Supreme Court judge, who has held office as a judge of Supreme Court. Once you have held office of judge of Supreme Court, whether you resign or you retire or you die, I mean, dying is not applicable here, but if you resign or retire, it does not matter. If you have been a judge of Supreme Court, even for half an hour, you will not be allowed to practice law in any court in the country. No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. Are we clear? This is a constitutional provision. Article 124, Clause 7. One more provision to ensure independence. Okay? Whenever you have retired as a, or if you have acted as a Supreme Court judge, take the example of Justice D.Y. Chandrachud. He is a Chief Justice of India. What if today he resigns? Can he start practicing law? Can he become an advocate in India from tomorrow? Tell me, yes or no? Why not? Why not? Firstly, answer is no. Second reason, why not? Because this can result in being biasness, right? He can give undue favors to some company, etc., and after retirement can become their company's corporate lawyer. So to ensure that the judges are completely independent, free from any influence, nothing can influence them, right? Are we clear on this? Nothing can influence them in future. So if you have been a Supreme Court judge ever, for 1 day, for 10 days, 100 days, does not matter. On your retirement or on the end, if you resign also, you will not be allowed to act as an advocate anywhere in the territory of India. Clear? Akash, that will not be possible. We have lawyers. Okay? How we become CGI? Megha, what are you doing, madam? What is this here? What did you do on Saturday and Sunday? How do you become Chief Justice of India? Do you think, guys, it's appropriate to ask this question now? Tell me. How to become Chief Justice of India? Senior most Supreme Court judge becomes a CGI. If you ever download the PDF and just look into it for 2 minutes. So this is the salary and the oaths. Their salaries will not be reduced to the disadvantage. Means their salary will not be reduced while they are working. This is to ensure independence. Imagine today there's a very, very important case going on in the court. Article 370 case going on against Government of India only. Today the government can say, in this special session, we are going to bring a bill to reduce the salary of all the Supreme Court judges to 10 rupees per month. And they make a phone call. Judges, give the judgment in our favor or else we'll pass the bill. Mind you, this is the problem, right? That is why we have this kind of provision. Okay. Moving on to retired and ad hoc judges. Now, what is this? See, when it comes to the Supreme Court of India, what about seat in the Supreme? Prem Kumar, nothing else is mentioned. The retired judges can take up the seat in Rajya Sabha, can contest elections, can become president, can become vice president, can become governor. All other things are open. What is not open is them acting as a lawyer in the court. That's it. Okay. Now, if at any point of time in the Supreme Court, quorum is not met, what is the meaning of quorum? Quorum is not met. Now, in case of parliament, the quorum used to be 10%, but here quorum is not defined. So we can just make an assumption that maybe if at any point of time there are very few judges, then the Supreme Court CJI, the Chief Justice, can order High Court judges to attend the Supreme Court. They will not become a Supreme Court judge. They just have to come and help the Supreme Court out in solving some cases. That's it. What's the condition? Prior permission of the president is required. What's the condition? You have to consult the Chief Justice of the State High Court from where we are calling the person. And number 3, the judge you are calling should be qualified to be appointed as a Supreme Court judge. So what is the criteria? If you are a High Court judge, what's the criteria to become a Supreme Court judge? Tell me. How many years should you work in the High Court, which will make you eligible to be a Supreme Court judge? 5 years. Don't write 10. 5 years. Okay. This is Article 127. Now, one small point. If the High Court judge is called to Supreme Court, come on, come and help us out. The High Court judge cannot refuse. Must attend. He cannot say, no, sir, I can't come to Delhi. Too much of pollution. Cannot say, no, sir, I'm feeling too shy. I can't come to Supreme Court. I'm too embarrassed. Sorry. No excuses. You have to come. Clear? Then we have Article 128, which means retired judges can also be called. CJI can order retired Supreme Court, High Court judges to attend the Supreme Court. If lot of pending cases are there, like as per the latest data, now the pending cases, registered and unregistered, have reached 80,000 plus in Supreme Court. More than 80,000 registered and unregistered cases. 80,000 plus cases. If the Supreme Court feels that let's call some retired High Court judge or Supreme Court judge only to come and help us out, it is possible. With the prior permission of the president, right? You can call the person. Okay. And retired High Court judge should be qualified to be appointed as Supreme Court judge. That's the only criteria. But here, you are calling retired people to come and attend. They may refuse also. They can say, sorry, I will not come ever to Supreme Court. Bad place. I am enjoying my retirement life. Please don't disturb me. They can refuse. These people cannot refuse. Okay. Now, moving on to Article 129, a very, very important article, Court of Records. In our country, Supreme Court is called Court of Records. COR. I know I'm treading in very dangerous waters because people will ask me, sir, what's the meaning of verdict? What's the meaning of evidence? I'm sure of it. So before you jump and ask, let me please explain the points. Okay. See, Supreme Court is the highest court of appeal. Also high courts. Both Supreme Court and the high courts are the constitutional courts. They are called court of record. Why? Because these courts have record room where records are stored. Yes or no? No. Why they are called court of records is that verdicts have evidentiary value. Meaning, if the Supreme Court gives any verdict, any judgment, any order, that becomes a fact. It becomes a fact for all the lower courts. If the Supreme Court says, sun rises from the west, all lower courts will say, yes, my lord, and they'll start giving judgment, keeping in mind the fact that sun rises from the west. Are we clear? Now, this is an extreme example. Don't think Supreme Court judges will ever give this kind of judgment, right? Anyway, and the judgments that they give are used as precedent, as an example by lower courts. Supreme Court and High Court judgments will be used by lower courts in giving judgments in their own cases. That is called court of records. Are we clear? Supreme Court under Article 129, High Courts under Article 215. Both these courts are called court of records in the country. Court of records in any country have two special provisions. Provision number 1. Every court of record has the power to review its own decisions. If a judgment is given by the court, Supreme Court or High Court, you can go to the same court and ask them, sir, my lords, I have come again. Please recheck problem in your judgment. You can do it. Okay. This was said by Supreme Court in the Shivdev Singh case, 1963. Apart from this, the Supreme Court and High Courts have the power to punish for contempt. What's the meaning of contempt? While we are discussing the chapter Parliament, I gave you a generic definition of contempt. We'll discuss more on this when we study fundamental rights. But contempt means making derogatory remarks about the court or not following court orders. Are we clear? Everybody? So every court of records has a power to punish people for contempt. This is a special power that the court of records have. Are we clear? Lower courts don't have the power to punish for contempt. They can punish you for misbehaving inside the court under separate laws, but they cannot punish you for contempt, which is a specific word which is mentioned in a separate law called Contempt of Court Act 1971. These are two special features of court of records not mentioned in the constitution. They exist in the implied sense or through Supreme Court judgments. I hope this point is clear. Okay. Now, lastly, Article 130. This is with respect to seat of Supreme Court. Tell me, where does the Supreme Court sit? Where does the M. Padmavati? Don't worry, we'll discuss contempt of court later on as a separate topic. Just remember this point, that power to punish for contempt is a special feature of Court of Records. Supreme Court sits in New Delhi. That is mentioned in the constitution that Supreme Court shall sit in New Delhi. But can the Supreme Court sit in other places? Yes, they can. If the Chief Justice wants and the President allows. Meaning, if the center allows, they can sit in any other place. Of course, center's permission is required, because to set up a Supreme Court, we need money also. So today, if our judges say, we want to give all the judgments for the next coming 4 months from Goa, let's go to Panjim. Come on, guys, pack your bags. Flight to Goa. From tomorrow, judgments in Goa. Now, for that, you have to take the permission of the president. Clear? That's there. Now, there is a small suggestion here. What's the suggestion? The suggestion is that, see, if you observe, let's take this as a map of India. This is Delhi. If at any point of time some judgment comes in Jammu and Kashmir High Court, Punjab Haryana High Court, Jodhpur High Court, Lucknow Allahabad High Court, etc., people can very easily approach the Supreme Court. Proximity, distance. But from Madras High Court, from Bangalore High Court, from Gujarat High Court, from Guwahati High Court, there is lot of distance, right? Lot of distance. Now, in this situation, it has been observed that the farther you move away from Delhi, the lesser are the appeals. Because don't think that you come to Supreme Court, you file a case on the same day, you are given the date. No. On an average, it can take 3 to 4 years for Supreme Court to give a judgment. How many years? 3 to 4 years on an average. Clear? So why should distance be an impediment in the delivery of justice? That is why the suggestion is that we should set up multiple branches or benches. 4. One in Delhi, one in Calcutta, one in Bombay, and one in Chennai. Though this has not been accepted by the Supreme Court, but it's a pretty decent suggestion. We can have multiple benches of the Supreme Court, of course. Anyway, Souvik, can the changing of the seat be called discretionary power of president? Sir, guys, one of our innocent person asks, is this discretionary power of president? What is your opinion? Tell me, please. When I was discussing the chapter precedent, I had told everybody, have faith. There is a list of discretionary powers. Only those things are discretionary powers. Nothing else is a discretionary power. At any point of time, if you find something, it is not a discretionary power. Godavari, sir, if Supreme Court seeks permission of President to transfer a High Court judge to Supreme Court, why will the Supreme Court seek permission of President for transfer of High Court judge? That for attending Article 127, that is just a formality, right? That is not the binding permission. It's just a formality. Palak, President's approval, no voting in the Parliament. Yes, Prem Kumar, of course, Supreme Court can change its judgments. Prosecutors, lawyers, Ankita. Okay, we are done with the basic information. Now let's move on to the jurisdiction of the Supreme Court, starting with the very basic jurisdiction. What is jurisdiction? Tell me. Power of Supreme Court, area of exercise of power of the Supreme Court. Okay, that is called jurisdiction. Now, original jurisdiction. This means two things. Direct, exclusive. What is direct? What is exclusive? There are certain types of cases for which we can go to Supreme Court directly. If there is a criminal case, if somebody has stolen something or somebody has been harassing you and somebody has beaten you, can you directly go to Supreme Court? You cannot. You have to go to a lower court first, then to High Court, and then if you have money, and then if the case is important, you can go to Supreme Court, right? So this is the flow of events in the filing of case. But there are certain situations where you can directly go to Supreme Court, direct. And not just this, you can go only to the Supreme Court. Exclusivity is also there, meaning no other court shares this power, or no other court can adjudicate or take up the case. Other courts have no power only. A very simple example is federal disputes. What are federal disputes? Photograph on the screen of two great leaders of this country. Center versus state, state versus state, center and state versus one or more states, etc. Tell me an example of any other provision, any other matter which can be solved by the Supreme Court only. Guys, please don't write fundamental rights. Can we not go to the High Court for fundamental rights protection? Tell me. Those who are writing fundamental rights, if we can go to High Court also, then how is it exclusive? The right answer is Article 71. Now, innocent people, please tell me, what is this Article 71? Election dispute involving The president and the vice president. It was taught to you a long time ago. Come on. Are you serious? Will that be possible to remember? It's been so long. Right? Of course. No problem. Article 71. That's it. Okay. Original jurisdiction. Simple. Solve this very difficult question. Megha, once again, sir, if I do nothing, but anyone filed a case against me, it for this, if warrant came for my name, what can I do? Megha, I will file a case against you, for sure, for asking this question. Arey, madam, you hire a lawyer. What can you do if somebody files a case? Hire a lawyer. Let the lawyer decide on what is the case. Read the case first. What's the case? What's the allegation? Right? And then act accordingly. Anyway, you have to hire a lawyer in the court. You can't fight your own case. I hope you're not a lawyer. I'm not sure. Maybe you're a lawyer. If you are an advocate, good for you. If not, hire an advocate. Okay, great. Easy question. It seems original jurisdiction, dispute between the government of India, yes, and one or more state, yes. And dispute between two or more states, yes. Both are correct. Then, a dispute regarding elections to either House of Parliament or that of state legislature is wrong. It goes to high courts. And a dispute between the government of India and a union territory also goes to high courts first. Okay. Clear? Now, appellate jurisdiction. Why not UT and government? UT and look at the name. Union territory. It is a territory which is a part of union only. So how can you file a case? This is not a federal dispute. It's the center against UT, an area controlled by the center only. Center against itself. That is not a federal dispute. It goes to High Court first. Are we clear, Anushka, now? Okay, great. Now, appellate jurisdiction. Appellate by way of appeal. So let's see the entire structure now of how the court functions. Some of you are enthusiastic to get a case filed against you. We start with the subordinate courts, also called trial courts. So any innocent as person can face a problem. Case is filed here. Okay, let's take the example of one student here, Megha, who was wondering what to do when a case is filed against her. Okay, so case is filed against her. She fights a case, hires a lawyer, but the judgment comes against her. Right? Now, next stage would be that she would say, now let me go to which court? High Court. She goes to High Court. So from here, the matter goes here. Now, in the High Court, we have a single judge bench or a two-judge bench called division bench. Don't panic, I'm writing here. Don't panic. SJB, a single judge bench. How many judges? One judge. DB is called a division bench. How many judges? Two judges. So you have to file a case here, and then the case can be appealed here. Okay? In the same court, it can be appealed. Now, one more point to understand. No, Prem Kumar, that is not correct. Bhuvnesh, are you serious or is it like a joke? Maybe it's a joke only. It's a very bad joke. I just had a minor heart attack reading that very pathetic joke. Why not more benches? Each bench costs only 12,000 rupees, sir. We should have hundreds of benches. Okay. A bench means a group of judges. Just like what is a bar? Not the bar you are thinking of. Guys, please calm down. Bar means a group of lawyers. Okay, so I know what I'm dealing with here, so please. Bar, group of lawyers. PJ is being cracked. Not even good quality jokes to laugh at also. Anyway. So, please understand, High Court also has the power to interpret the Constitution. Constitutional matters can go to High Court also. I will give you a simple example. There was an issue recently which is still pending in the Supreme Court, and that issue was what? That issue was with respect to the hijab ban in the state of Karnataka, if you have ever heard of it, right? So hijab ban was firstly discussed in Karnataka High Court, and then the case was appealed in Supreme Court. So in case it's a constitutional matter, for constitutional matters in High Court only, we have three judge bench, three judges sit here, but just for High Court. Now, if the lady who was the person who had filed a case, I forgot her name only now. Megha, yes, I remember now. Yes. Now she is very upset that again the judgment has come against her. Now, which place can Megha go to? Come on, Megha, you tell me. Which place will you go to next? Supreme Court, of course. But let me just clarify one thing here, and let me break one misconception that people have in the country. Not everybody can go to the Supreme Court. Are we clear? Only certain types of matters can go to Supreme Court, and there is a proper condition for it. Oh, slip of tongue, guys. Oh, there should be a proper condition for it. What's the condition? See, in the Supreme Court, firstly, we have no concept of single judge bench. One judge does not sit and give judgments in Supreme Court. In the lower courts, one judge sits, only one judge. In High Court, we have both kind of things. Firstly, a matter goes to one judge. If you are unhappy, then two judges. But in Supreme Court, every case is decided by two judges only. It's mandatory. Then, for more important matters, we have a priority bench, and then for constitutional matters. So PB stands for priority bench, which means three judges, and CB stands for constitutional matters, right? constitutional bench, which is at least 5 judges. So if you have less than 5 judges, it cannot be called a constitutional bench in the Supreme Court. Now, the matter goes here. Now, Supreme Court will decide which bench to allocate the case to, depending on the type of case and all, that they will decide on their own. Anyway, for this to happen, you have certain conditions which have to be met. Conditions. What conditions need to be met? Conditions. First things first, very simple. There is a concept called Article 134 capital A. Basically, in case you want to appeal in the Supreme Court against a High Court judgment, you have to take the permission of High Court only. That High Court, please give me permission. I have to go and complain to Supreme Court. Your judgment is very, very bad. You won't say that. You will say that judgment is very amazing, sir. My lords, you are genius. But I want to go to Supreme Court. Please, my lords. You can start crying there, roll on the floor, do all the drama. If you can convince them and they give you a certificate, only then can you go to the Supreme Court. High Court gives certificate of appeal. Appeal in the Supreme Court. Or, very important, if your matter is a constitutional matter, then we know very well which is the final court of appeal. If it's a constitutional matter, then Supreme Court is the final court of appeal. No problem only. Or if it's a civil matter, a civil case, matters of larger public importance. If it's a very important matter, matters of larger public importance, then you can go to the Supreme Court. And in a criminal case, if the High Court has reversed a lower court judgment and has given you at least 10 years jail, at least 10 years of jail. If this is a situation, you can appeal in the Supreme Court. Look at this. This is Article 132. If it's a case which requires interpreting the Constitution, we know very well Supreme Court is the final interpreter of the Constitution. Very simple. Or number two, if it's a matter of larger public interest but a civil matter, then of general importance, then you can go to Supreme Court. Or Article 134, if your case is a criminal matter, High Court has reversed the lower court judgment and has given you 10 years of jail sentence. In the Constitution, it was mentioned death sentence. But in 1970, a bill was passed which modified this. That bill was called the Supreme Court Enlargement of Criminal Appellate Jurisdiction. Right? So, this is with respect to what? The modification made that from now onwards, even if the case is what? Even if the case is one where the High Court has reversed the judgment and has given you what kind of punishment, even if a 10-year jail, then don't worry, you will be allowed to appeal in the Supreme Court. Clear? So that is with respect to the Supreme Court. Clear? Okay. Done, Gaurav? Clear? Yashwant, Supreme Court decides. Lakshmi, we don't have jury system. It won't work here. Anushka, in case of constitution, it is Article 131 capital A. Sir, Anushka, there is no Article 131 capital A. You'll be surprised. It used to be there. It has been repealed. I'm so sorry to break this news to you that in 1976 only it was repealed. Right? Anyway, 1977 through the 43rd Amendment Act, it was repealed. So sorry. Let's move on now. Are we clear, everybody? This is how appeal works. Yes or no? Okay. Yes. Rakesh, here only some judges are sitting. Arey, sir, Rakesh, not only one case comes to Supreme Court. Hundreds of cases, thousands of cases come to Supreme Court. So multiple judges are sitting in multiple cases simultaneously. It's not just one case. Multiple cases at the same time. So this is how you go to Supreme Court. Now look at what I have told you here. I am telling you, if it's a constitutional matter, if it's a matter of larger public interest, if the punishment is 10 years of jail, see, you will say, but sir, we see that all these people, constantly, the rich elite people, 4 years punishment, 2 years punishment, they go to Supreme Court. Rahul Gandhi, 2 years jail, he has gone to Supreme Court. How? How is this happening? Calm down. There is an option. What's the option? The option is called special leave petition. Leave means permission. So what you can do, if the High Court has not given you certificate and your case otherwise is not fit for appeal under Article 132, 133, 134, then you can request the Supreme Court that Supreme Court, nobody is giving me certificate. My case is also not that important. Please, but Supreme Court, I think you are the best judge on this whole planet to take up my case. Please, my lords, take up my case. If the Supreme Court accepts, good for you. If not, tata bye bye. The judgment of High Court is final. Right? So this is actually an option. It is not some kind of right that you can claim that, come on, Supreme Court, accept my case. No, no. You are basically going to Supreme Court, requesting the Supreme Court at Supreme Court, nobody is giving me certificate. Please, you are everything. You give me certificate. Right? Supreme Court may grant special leave, permission. Leave means permission to appeal from any judgment, any order, in any cause, any matter passed by any court or any tribunal in the territory of India. Of course, Supreme Court may or may not accept the SLP, special leave petition. This is a part of Article 136. Now you will say, but why should the Supreme Court accept this petition? If the punishment is very small or the matter is not important, High Court has not given certificate, then why? See, reasons for accepting SLPs. See, if the Supreme Court feels that grave injustice has happened to you, grave injustice, miscarriage of justice has happened, or new facts come to light, meaning some new evidence has come, that then also Supreme Court can take up the case, or there is a case of violation of principles of natural justice. Okay, PONJ. What is the meaning of PONJ? Principles of natural justice. Let me explain this point. Please remember this. This is not mentioned in any article. These are principles accepted world over to ensure fairness. When it comes to fairness part, we follow this to ensure fairness. Have you heard of this term by any chance? Recusal. Have you heard by any chance this word recusal? Recusal means, see what happens is, let's assume that you and your neighbor are fighting, and your father becomes a judge, or your best friend becomes a judge in that case. He decides who is right or wrong. Do you think it is fair? Tell me. Of course not. Maybe your friend can say, no, I'll be very, very fair. But that is not the problem. You may be the most fair person. It is of no concern. Justice should be done, but it should also be seen to have been done. Here, justice is not being done and not being seen as being done. So, recusal means if a judge is allocated a case and he knows either of the party, if he has any prior association with any of the litigant involved in the case, he will say, I cannot take up the case. Sorry. Please, Chief Justice, don't make me a judge here. Simple. Judge opts out of a case due to prior association with any party. Any party does not mean political party. Litigant, those who are involved in the case. Okay, to ensure fairness. Are we clear? Okay. This is a very important thing, which is also a part of natural justice, which we say is nema causa in judex sua. Relax. It simply means the right against bias, meaning no one shall be a judge in their own case. If you are a judge in your own case, where is the fairness? To give you an example, a couple of years back, the 46th Chief Justice of India, Justice Ranjan Gogoi, who is now an MP in the Rajya Sabha, there was a case against Justice Gogoi. Some one lady who had been working in the Supreme Court under, of course, Chief Justice of India only. She was removed from the office and all, and she had filed a complaint that alleging that Justice Gogoi had sexually harassed her. Now, Supreme Court formed a committee to look into this complaint. In that committee, the head was Justice Gogoi himself. Tell me, is this fair? What do you think? So, this is not fair because it violates the first principle of natural justice, which is no one shall be a judge in their own case, nema causain judex sua. Clear? Second, this is the right to fair hearing. Audi alterum partem. Here, both the sides. Do you remember, especially if you are an older sibling, do you remember that if at any point of time the younger sibling and you were fighting, and the younger sibling has a tool which is called what? The younger sibling has a tool called crying. He starts crying immediately, or she starts crying immediately, and the mom would come in the room and start beating you without even giving you an opportunity to explain your point of view. Yes or no? So, in that case, you are not giving the other person the fair chance of hearing. Hear their point of view also. What went wrong? So, next time it goes wrong and this happens to you, you please tell your parents. Principle of natural justice is getting violated. Now, they may slap you more, but polity wins. At least you have made your point. They'll be happy also that my kid is learning something, right? Okay. So this is called the right to fair hearing. And lastly, the third principle is giving reasons for judgment. Whenever any judgment is given, it should have the reason. Without reason, judgments are not held as valid. Clear? So next time you approach somebody and type nice DP, I love you a lot, you express your emotions to them and they reject you. You ask them, tell me why. Okay? And if they deny, you tell them principle of natural justice is being violated. This is unfair. Are we clear? Nothing may happen, but polity wins in the end. Principles of natural justice. Okay. Because of personal problems, what to do? Okay. So this is the special leave petition. This is one way where you can go to the Supreme Court, but please don't expect that Supreme Court will accept your case. The rejection rate is very high. 90% cases are rejected. Okay. Acceptance rate of SLP is very, very low. Right? Very, very low. Now, do you remember your school days when the marks were given to you after the test or examination? Some emotional aspirant should always be in their dreamland that maybe some calculation mistake has happened. If nothing was of that sort happened, they would always go to teacher, Miss, more marks. 2 more marks, 1 mark in this question. Always trying for this revaluation to get some more marks, right? Because you know what happens in the house. So the problem is that the same thing can happen in the court also. There is a provision in the court where you can request the court that, court, your judgment is not nice. Can you please give me one chance to appeal again? And the court can, if it wants to. This is called revisory jurisdiction of the Supreme Court. Revisory jurisdiction. Or let's write like this. You can file a petition which would be called a review petition in the Supreme Court. What will you file? Review petition. Okay. This is mentioned under Article 137. Supreme Court shall have the power to review any judgment, pronounced, or order made by it. You can approach the Supreme Court under Article 137. Supreme Court may or may not accept it. Number 2, must be filed within 30 days of the date of judgment. Right? Are we clear on this? It can only be filed once. Once. Done. So, who was the person? Megha was the person. So, Megha was still unhappy and she filed a review petition in the Supreme Court. She is still unhappy. Judgment comes and she's still unhappy. Now, what can Megha do? Nothing is mentioned in the Constitution beyond this. End of story. But there is one small window of opportunity for Megha here. And what is that window of opportunity? We will discuss this after the break. Let's take a break. Be back at 7:05 and we'll discuss what is that scope to file for re-evaluation one more time. Okay? Break please. Come back at 7:05 and we'll continue our discussion further. That you are getting a chance to ask the Supreme Court to reconsider their judgment. Example, Sabrimala. In the Sabrimala case, when the Supreme Court gave a judgment, a review petition was filed seeking a re-evaluation of the judgment, right? Now, as we're discussing, one of our innocent aspirants is trapped here and she has filed a review petition and the case is still not coming in her favor. She is very upset. What to do now? Constitutionally, nothing can be done. But in the year 2002, Supreme Court said, let's see, the act of court shall prejudice no one. Meaning, courts are under the obligation to undo any kind of wrong, even if the wrong has been done by an act of court, right? So the court says that judiciary can go to any extent to meet the ends of justice. You want one more chance? One more chance. Try once again. Convince us once again. Present your facts once again. No problem. So we have an opportunity to file what Supreme Court has created as a concept curative petition, What is curative petition? Curing the wrong done by the court or by any person. So this is filed on the failure of review petition. Okay. And this is a Supreme Court innovation. Meaning it is not mentioned in the Constitution. This was a Supreme Court innovation in the Rupa Hurra case of the year 2002. This is not mentioned in the Constitution. Are we clear? So you can file a case once again called curative petition, but it is not mentioned in the Constitution. Clear? What if after this case you are still not happy with the judgment? Then what to do? If you have filed one more revaluation and still the result is the same, then what do? Sit at home and cry. Simple. End of story. We have to stop somewhere. We are stopping at this point. Judiciary says we have given you ample opportunities to appeal. Now done. Please take the punishment or go home. Don't disturb us. Are we clear, everybody? The judicial journey of your case is over. Okay. Prem, clemency is not a judicial power, number one. And number two, clemency only for punishments, not for other matters. Okay. Article 137, curative petition. It is filed when the review petition fails. You are given one more chance to convince the judge that some injustice has occurred. What is grave injustice? What is miscarriage of justice? It simply means injustice has been done by the High Court towards you. Maybe the High Court has given you a very harsh punishment. Maybe the High Court has not given you a chance properly. If you can prove all this, good for you. That's it. Okay. Lakshya, how curative petition is filed? Need to know. You need to know how it is filed. Are you filing a curative petition? You go to Supreme Court, file a case under this curative petition. Simple. That's it. Durga and others, there is no option beyond this. Some of you are claiming, sir, clemency. Clemency is not a judicial power. Do you even remember the clemency provisions? There was a specific line mentioned. It is outside the judicial system. Are we clear? Clemency is not challenging Supreme Court's judgment. Clemency is accepting the judgment and seeking apology. And clemency is limited to only punishments. Right? Lakshya, no, not required. This is sufficient information. Nutikadi, yes, curative petition, 30 days. Are we clear, everyone? So that is it. End of story of your case. So we have to say sorry to Megha that you have to stop at curative petition. That's it. Okay. Now, one more jurisdiction. Manish, how long will it take to complete the entire process? Manish, to complete the entire process, only God knows. Soya, please understand, President can override Supreme Court decision. Supreme Court decision is not being overridden. Are we clear? It is like Supreme Court has given the punishment. You are accepting the punishment. You are only asking the President, please forgive me. You are not challenging a Supreme Court order. Okay. Astha, the Supreme Court decides based on your case. Normally, it goes to a two-judge bench, then to a three-judge, and then to five-judge, depending on the case matter. Gaurav, 30 days. Okay. Solve this question first. I have some very interesting. Of course, of course, of course. Let's read. Let me explain before panicking. With reference to Indian judiciary, any retired judge of Supreme Court of India can be called back to sit by the Chief Justice of India with the prior permission of the President of India. We know this is correct. This is Article 128. No problem. Very good. Now coming to the second statement. A High Court in India has the power to review its own judgment as the Supreme Court does. Tell me yes or no. High Court is a court of records. Yes or no? Is High Court a court of records? Yes. Do we not know that court of records have the power to review their own decisions? Yes or no? Supreme Court's judgment is there. This means what? Power to review is there. This means this statement is correct. Right answer is C, both 1 and 2. Okay. But when the answer key for UPSC came, the correct answer given was A. Okay. But the actual correct answer for this question is C. Why I say this is because poll was A because I chose A as the answer, right? I choose the poll answer. Why I say this is because in the year 2020, there was a Kerala High Court judgment which said that the High Court can review its own decisions as per Supreme Court judgment Shivdev Singh case. Right? This is a Supreme Court and High Court judgment. Now, there is an Article 137 specially for Supreme Court. There is no such special article for High Court. It is in the implied sense. So if the question had mentioned with reference to Indian Constitution, then 2 would have been wrong. But it is not mentioned. So 2 should be correct. But right answer is given by UPSC is A. But what can you do about it? You can do nothing about it. Simple. Accept it, move on in life. That is why we say that please score 100 plus marks so that you don't fall prey to such silly things. That is why UPSC will never reveal the answer key, will never reveal anything before the end of the entire exam process, so that the exam process is complete. Dhanya, what is the confusion? Tell me. Do you have a confusion on this question? Shahid, firstly, the question will not repeat itself. If it does, I will still say that second statement is correct. On the answer, what's the problem here? If this question comes again, I will tell you, please mark C as the answer. It will not come again ever, but if it does, because C is the correct answer. Just because UPSC gave a wrong answer, we cannot change our facts. Don't worry. Arey Dhanya, I am telling you the correct answer. Can you read the statement here? Slightly challenging, but try to read it. Correct? Answer C. Okay. It's a very basic thing. Please understand. In your school also, college also, everywhere mistakes can be made, right? This is UPSC's mistake. UPSC is not God. Even God makes mistakes. Look at the IQ level of some of the students here, right? Mistakes can happen. This is an honest mistake. Let's ignore it. Okay? Soya, that petition has already been discussed earlier also. And Dhanya, I polled A to let you know what UPSC's answer key was. Okay? And that's my choice. Complete choice. Okay? Dictatorship, if you may say so. Okay? But yes, to cut a long story short, guys, and on a more serious note now, these things will happen. Trust me. Okay? No more jokes. These things will happen. Because see, it's an examination where UPSC is not selecting making the questions. People from various colleges are asked to submit questions, and UPSC just picks questions. Mistakes can generally happen. It is very natural, right? So we have to learn to ignore all these things. Bhuvnesh, who is making UPSC papers? Don't go and kill him, Bhuvnesh. Please, it's okay. Forgive him. Don't worry. Asif, the maximum limit is decided. So you get the pension plus any extra amount which will make the total equal the current salary you are getting. That's it. You can't get both the things, full amount. That's not possible. Now coming to advisory jurisdiction, Article 143. Have you seen this movie Three Idiots? Of course. Or in other language, in Tamil, Nanban, I think was the movie. I'm not sure what was the name in Telugu, etc. But a very, very popular movie. Some have not seen this movie. It's okay. I'm not sure what is left then. Maybe you are very studious. That's possible. See, in this movie, Amir Khan or Vijay in Tamil, who was the actor in Telugu? Who played the role of Amir Khan in the Telugu version? Vijay. So it was a Tamil one which was dubbed in Telugu. Let's say like this. Okay. I thought that it was a different version, like the Munna Bhai movie. It's Shankar Dada and Vasool Raja. So you have Kamal Hassan and Venkatesh playing different roles. Say it was dubbed in Telugu. Okay, so it's a Tamil version only. So whether you have seen Vijay or you have seen Amir Khan, they have this habit of giving free advice. UPSC will not give free advice. Number one, no free advice. Advice only when asked. And who will ask? The president will ask. Okay? So, in this situation, president seeks opinion of Supreme Court on two things possibly. Supreme President can seek opinion, maybe a legal opinion, on general matters. Let's say the government wants to file a case in the court, but it wants to know whether they have a strong chance to win the case or not. Are the documents correct or not? They can approach the Supreme Court and seek their opinion. Supreme Court, what do you say? Should I file a case? because every case the government files, mind you, it's a wastage of taxpayers' money only if the government loses a case, right? So in that case, second could be asking Supreme Court to interpret laws on the interpretation of laws. Now, if you are asking Supreme Court some legal opinion, Supreme Court may or may not give advice. It can simply say, no, I will not. Go ask your Attorney General. Don't disturb me. But if you are asking Supreme Court that Supreme Court please interpret this article for us, what's the real meaning? Then Supreme Court must give advice. Must give the opinion. Let's use the word opinion. This is also known as presidential reference, or also called RE. So if you at any point of time see RE mentioned somewhere, know that it is not a judgment, not a case in its true sense. It is Supreme Court being asked what is the interpretation of a law, etc. Anyway, whatever opinion Supreme Court gives, this opinion is not binding on the government or the president. Are we clear? As I explained, legal opinion on general matters is on any matter. Before filing a case in the court, the government can go and ask Supreme Court judges, what is your opinion on this matter? Should I file a case? What do you think? Will I win the case? Do I have strong ground to win the case? Soyab sir, why do you ask all these questions, sir? Just to embarrass yourself. Again, the same question. Is it president's power or council of ministers' power? Sir, how many times now? It is, these are all the council of ministers' power. President has no power only. What will he ask? What functions does he perform to go and seek opinion on legal matters? Tell me, which law is he making? Which order is he executing? So, it is a council of ministers power. Now, I'm tired of telling this after 15 classes. If I have to still tell you, no, bache, this is not the power of the president. Please refer to the original slides. What is mentioned there? Then a larger thing is you're not focusing or not revising. Anyway, this kind of advisory jurisdiction must be given by at least 5 judges. Minimum 5 judges must give this advice. It can't be given by one single judge. Are we clear? The constitutional bench or Article 143 bench, they must have at least 5 judges. I'll give an example of this one specially. Remember the collegium, the judge's case? Do you remember the judge's case? Third judge's case. Look at this. What is the third judge's case? Third judge's case is not actually a court case. It was the government seeking clarification from Supreme Court on what is the collegium all about. Presidential reference under Article 143. A classic example of this. Okay. Now coming to some Other provisions before that, solve a quick question first. Easy and simple. Don't make a mistake. When will I get to see 90% correct answers? When will that day ever come? Yes, Prem Kumar. Absolutely correct. Godavari. Berubari also was exactly the same thing. I just mentioned you don't have to act like Amir Khan. Don't give free advice. Supreme Court of India tenders advice to the president on matters of law or fact on its own initiative. When nobody is asking you, keep quiet. Only if the matter relates to fundamental rights. No, it can be on any matter that the president wants to, if he seeks such an advice. Two only. Are we clear? Now we have something called writ jurisdiction. What is the meaning of writ firstly? Writ means order or directive. That is called writ. Order or directive. This is mentioned under Article 32. Clear? Now, this writ or order is given by Supreme Court to protect fundamental rights. One small point, this writ jurisdiction is also a power of the High Courts. Also available with High Courts. Article 226. So High Courts also have the power to issue writs or orders, clear, for the protection of fundamental rights. But the beauty here is that you can directly go to Supreme Court. That's the beauty of this writ jurisdiction, that you can directly go to Supreme Court. But my question is, can you go only to Supreme Court? No, you can go to High Court also. So this writ jurisdiction is of course direct, but not exclusive, because it is shared with the High Courts. Are we clear? Everybody? So this is with respect to Article 32. Now there are various types of writs. What are those types of writs? I will discuss all that, but that discussion is better left for Article 32, fundamental rights. The writ of habeas corpus, the writ of mandamus, the writ of certiorari, the writ of prohibition, the writ of quo warranto. We'll discuss all this, don't worry. But we'll discuss all this only when we are discussing the fundamental rights. Okay. Okay. Asked if Supreme Court can said that we have no advice. This is advice. It can say that. What's the point here? Said no. What's your point? Supreme. Are you saying that the advice is mandatory? No, no. It is not mandatory. Article 143 says that the court may, after such hearing, uh, as it thinks fit, will report to the president its opinion. The court may report its opinion to the president. This is a phrase mentioned verbatim in Article 143, Clause 1. So that's the reality of the article. Rest, I am not sure. What is your intention behind quoting this statement? Anyway, uh, Yashwant, writ can be filed directly in Supreme Court, then wouldn't it be called exclusive? Sir, you are contradicting yourself. You are saying that writ can be filed directly in Supreme Court, but only in Supreme Court is a question. Exclusive means only in Supreme Court. Okay, that's the important point. Anyway, let's move on. These emotional questions. So questions for the sake of asking questions should not be there. There should be some strong ground behind a question. Now see, can Supreme Court's jurisdiction be enlarged by the Parliament? Yes, it can. And you will be surprised to know it can be done by law. After the Government of India and Government of State agree. GOS, guys, means Government of State. Please. GOI is Government of India and GOS, my bad, is Government of State. One small question before that. If you want to decrease the Supreme Court's power, what kind of majority is required? Difficult times. Haji. Okay, some of you are correct. Basically, it's the change of the federal structure, which means what? Which means special majority with the ratification of at least, or ratification by at least half of the states. That's it. Done. Anyway, uh, Supreme Court also has a power to transfer cases from one high court to another or to itself also. Back in the 2000s, a case in Gujarat with respect to fake encounter was transferred outside Gujarat to Rajasthan, which involved Mr. Amit Shah, because the Supreme Court felt that the administration of Gujarat could create obstruction in the delivery of justice. Bilkis Bano case was transferred from Gujarat to Bombay High Court because the Supreme Court felt that there could be a problem with delivery of justice when it came to Bilkis Bano. Recently, Nupur Sharma, who was then in BJP, I'm not sure what is her current situation with respect to party, she had gone to Supreme Court to seek Supreme Court's interference because against her multiple cases were filed all across the country, right? And she wanted the Supreme Court to direct all the cases in Delhi only, so that she could appear in all the cases at one place. So Supreme Court has a power to transfer cases from one high court to another or to itself also. Okay. But how can this be done, or when will this be done? Three cases. One would be suo moto. On its own motion. That is on its own. Suo moto. Suo moto, suo motu, MOTU, same thing. Second, if any party or litigant requests, or if Attorney General requests, because Attorney General has to take up multiple cases. What if there's some case in Madras High Court, one in Bombay High Court, and three in Supreme Court? He can't go to all the places. So he'll ask the Supreme Court, please call those cases here only. I can attend all the cases in one place. It will save the government and its money also, which I have to use for traveling. Clear? That's there. And lastly, Article 141. The law declared by the Supreme Court shall be binding on all the courts within the territory of India. Inside the territory of India, whatever Supreme Court says is binding on all the courts, because Supreme Court is the highest court of appeal. Now, we all have heard this term called activism. Have we not heard of this term called activism? Judiciary interferes everywhere, telling others what to do. Everywhere. Here, there, everywhere. How does the judiciary get this kind of power? Telling the executive also, telling the legislature also, passing comments on everybody. There is a constitutional provision, Article 142. The article is framed in such a fashion that it gives a sense that Supreme Court can give orders. Let's read first for better understanding. Supreme Court, in the exercise of its jurisdiction, may pass such decree. Decree means conclusion. Decree means conclusion. May pass such decree or make such order as is necessary for what? Doing complete justice in any cause, any matter pending before it. Look at the wide range of interpretation of this article, that if I want to give, let's say, ensure complete justice, I can pass any kind of order, whether that order infringes upon the government's power or the parliament's power or the president's power or the God's power. I don't care. My task is to ensure justice, and to ensure justice I can take orders, or I can give orders on any aspect, in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India. Are we clear? Absolute powers of Supreme Court. Article 142. This is the source of judicial activism. Okay. And then lastly, Article 145. Rules of Supreme Court. Who makes the rules? Supreme Court itself, with the approval of the president. And this is just a formal approval. Okay. With the approval of the president, the Supreme Court can make rules for regulating generally the practice and procedure of the court. So what is the court fees? What is the way in which cases will be filed? What are the guidelines to file a case? Which case goes to which bench? Everything inside the court is decided by the court itself. Then minimum number of judges to decide on matters of interpretation of the constitution or matters under article 143 shall be how much? Shall be 5. Basically this. Minimum 5 judges. Constitutional bench, how many? At least 5 judges. That's how it is. Lastly, all decisions in the Supreme Court or the High Courts also, but here Supreme Court, are given by a majority judgment. So if there's a 3-judge bench, 2:1. If there's a 5-judge bench, 5:0, 4:1, 3:2. That kind of judgment. Are we clear? And don't have this misconception that what if CGI gives other judgment? It does not matter. CGI, while being a part of a bench, is just like any other judge, right? If he is a part of majority, that's a judgment. If not, does not matter. We are not interested in what is the CGI's personal judgment. We are interested in the majority judgment. Do we understand it? Now, one more point. Vaibhav, sir, one person is rich and second is poor. So the case of sexual harassment and the girl of poor and girl of rich, who will get justice? What kind of question, Vaibhav? I don't understand this question only. Lakshya, that means, sir, to get justice, people in international court for criminals. Why international court for criminals? No, not. Okay. Now, one small point. In Supreme Court, we have a concept of division bench. Yes or no? Yes. What is a division bench? How many judges? Tell me. 2 judges. If these 2 judges give a judgment, 1:1. Example, hijab ban. 2 judges. One judge says hijab ban is correct. Second judge says it is wrong. What to do now? Then what to do? Toss or arm wrestling. Judges, come on, arm wrestle. Whoever wins, that person's judgment goes. Yes or no? Of course not. Don't type yes, anybody, please. Okay? Basically, this is called a split verdict. This matter is then transferred to a priority bench, a 3-judge bench. Clear? Done. And just one more point. CJI is called the master of roster. What is roster? Tell me. Not one who roasts. No. I hope it was a joke. Oh. Master of roaster refers to the person who oversees the allocation of cases to different benches, formation of benches, and also allocation of cases to different bench. That is the meaning of master of roaster. It has got no relationship to roasting anybody. Are we clear? Okay. Great then. We are done with the Supreme Court. Now let's move on to the High Courts. How many High Courts do we have? We have 25 High Courts in the country. Okay. Every state has a High Court. It may not be inside your state. That is possible. Don't be a crybaby about it. But your state is allocated one High Court. Are we clear on this? So presently we have 25 High Courts. How many states do we have? Tell me. Great. I should have taken a poll. 38 and 28, some of you are writing, others are correct. 28 states. Very good. So high courts are 25, and in these 25 high courts we have in total 1114 judges. Number of judges varies from one high court to another. Example, if you look at Allahabad High Court, it has 160 judges. It is the largest high court in the country in terms of number of judges. Right? Okay. Sikkim High Court has just 3 judges. Bombay High Court, 94 judges. Okay. Manipur High Court, 5 judges. Tripura High Court, 5 judges. Meghalaya High Court, 4 judges. Punjab and Haryana High Court, 85 judges. Number of judges varies from one high court to another. There will be a common high court also possible for 2 or more states. This is done through the 7th Amendment Act. Just like we can have a common governor for 2 or more states, so we can have a common high court for 2 or more states. Are we clear? Satyapal, High Court's name has not been changed. It is still the Allahabad High Court, it's still the Madras High Court, it's still the Bombay High Court, it's still the Calcutta High Court. Are we clear? Please don't politicize this uselessly. Focus on clearing the examination. Pankaj, no sir, in your state, you only have one high court. Some judges sit in Gwalior, some in Indore, right? Like in the case of UP, we have the Allahabad High Court, but some judges sit in Lucknow also, because it's a big state. Like Rajasthan, Jodhpur High Court, but some judges sit in Jaipur also. Same goes for Tamil Nadu, Chennai High Court, Madurai also. Same goes for Maharashtra. For bigger states, High Court can have multiple branches. It's one High Court only. Are we clear? Now, High Court is there for each state and also for UTs. This is the table. My question to you, how many states or how many high courts serve more than one state? Type quickly. How many high courts serve more than one state? This is simple reasoning. It has got nothing to do with knowledge, because you can simply if I tell you the right answer, a lot of you are going to be disappointed. Should I break your heart, guys? Tell me. Okay, let's break some hearts. What was my question? How many high courts serve more than one state. Bombay High Court serves Goa and Maharashtra. Guwahati High Court serves Arunachal, Assam, Mizoram, and Nagaland. And Punjab and Haryana High Court serves Haryana and Punjab. All other high courts are serving a state and a UT. State and a UT. State and a UT. Only UTs. Clear? Reasoning. Understand, listen, comprehend, absorb the question, and then make a statement. Okay? Anyway. So that's it. Let's move on with this basic information at hand and solve this question which came in prelims 2006. Do we have anybody here who was not even born in 2006? Oh, of course, we have some people. I think only 2 people. Oh, 3 people. Tarun, Bhuvnesh, and Sardarni. Oh, Jishima also. And Siva. Oh, how could I forget? Sir, fourth option is A is false but R is true. Madan. Okay, it was an easy question. In India, every state has a high court in its territory, of course. Is this correct? Tell me. Tell me. How will this be correct? We have shared high courts. This will not be correct. A is only wrong. End of story. What to read now? A is true, no. A is true, no. A is true, no. D is the answer. Clear? Normally in assertion reason questions, this is what you will find. Either A is right statement or R is right statement. Now the appointment. Please tell me what is the appointment procedure of the High Court judges? Sorry, one more question before that. If we want to increase the number of judges, to increase the number of judges in the high courts, what's the procedure? Parliament by law. Yes or no? No. Okay, okay. Smart people. Those who are revising, very good. President can do it. Executive order of the president. We had seen this. The very first topic under judiciary was this only. In high courts, the number of judges decided by the president. Right? So that's there with respect to the high courts. Anyway, we also know Article 217. Every judge of high court shall be appointed by the president by a warrant under hand and seal after consultation with the Chief Justice of India, the governor of the state, and in the case of appointment of a judge other than the Chief Justice of the High Court. And judges of High Court shall hold office until they attain the age of 62, not 65. 62. But we know very well this appointment is also done by the process of collegium system, And what does the collegium here comprise of? CJI plus how many Supreme Court judges? 4 Supreme Court judges. Yes or no? Only 2. Don't write 4, but a lot of you are writing 2 only. So very good. 2 Supreme Court judges. 4 is for transfer. Right? This is for appointment. One more thing. There is also a concept of additional judge in the high courts. You also can appoint, and they do appoint, additional judges for maximum 2 years. Okay, that's it. That's it. Moving on to qualification. What is a qualification required apart from being a citizen and all? Don't say citizen. So the qualification required is you have to be either advocate in high court at least 10 years or more, or you should have been a judicial officer in the country for how many years? 10 years or more. Who is a judicial officer? Judicial officer means a judge in the lower court, district judge, judicial officer. Are we clear, everybody? That's the qualification. Now, the same qualification is there for which other person? Can you please tell me? Which other person has the same qualification requirement? Very good, yeah, guys. Excellent. Some of you are like really genuinely serious here. Advocate General. Every state has this person called Advocate General under Article 165. Same qualification. Okay. Now, a couple of other things. It goes without saying that what is the removal process? Tell me. Removal. Same as Supreme Court judge. Then salary. Where is the salary mentioned? Which schedule? Schedule 2. Where is the oath mentioned? Schedule 3. Now, salary is charged on CFS. What is CFS? Consolidated Fund of the State. But pension charged on CFI. Now, one more thing. Supreme Court judges on retirement are debarred from practicing in future. Yes or no? Tell me. Supreme Court judges are debarred from practicing in future. Of course they are. Now, what about High Court judges? Are they debarred from practicing in future? Yes and no. Yes also, no also. Yes, they are debarred from practicing in those high courts where they have been a judge. That's it. Debarred from pleading in those courts where they have acted as a judge. Are we clear? Meaning, can a retired High Court judge practice in Supreme Court? Tell me. Yes, he can practice in Supreme Court. Now, let me ask a question. Let's say there is a justice ABC. This justice ABC was a judge in Patna High Court. He got later on transferred to Sikkim High Court. And then finally he was made the Chief Justice of Bombay High Court. And then he retired. My question is, will this judge be allowed to practice in Patna High Court after retirement? No, he will not, because you will not be allowed to plead or practice in those courts where you have been a judge. Point one. Point two. Will this Justice ABC be allowed to practice in Calcutta High Court? Yes, of course. Very good. Will this judge be allowed to practice in Bombay High Court? No, of course not, because he has also been a judge at Bombay High Court. Are we clear? So I think now this point has been understood. Now, lastly, the jurisdiction. Very simple. Three types of jurisdiction. One is original. Any election dispute involving MPs, MLAs, MLCs, that goes to High Court. Any election dispute involving the president's or the vice president's election will go to Supreme Court. Okay. Second is the admiralty laws involving law of seas. For example, if this is say peninsular India, if something happens here in the territorial waters of India, then the jurisdiction is of the corresponding high court. That is called admiralty, involving law of seas. Are we clear on this? Everybody? Okay. Then appellate. See, what is appellate? Everything is appellate. High courts were actually created to act as an insulating layer between the lower court and the Supreme Court. So every case can go to High Court. There is absolutely no need of any kind of certificate, any condition requirement, nothing. All civil and criminal cases can be appealed in the High Courts. And writ jurisdiction, that is for the fundamental rights. For protection of fundamental rights plus other matters, the High Court can issue writs. Original jurisdiction, you can directly go to the High Court and only High Court. Going to Supreme Court is through appeal only. Electoral disputes, meaning election disputes of MP, MLA, MLC. If there is any electoral dispute involving the election of an MP, MLA, MLC, the matter goes to High Court directly. Okay? Or if any kind of law is violated, which is a law of seas, any crime is committed in the territorial waters, then the corresponding High Court gets the jurisdiction. Clear? Everybody, Mayank Wadhwani, Dhanya. Okay. Writ point we just saw in Supreme Court, same thing. The High Court can issue orders. What is a writ? Order, directive. High Court can issue writs to protect the fundamental rights or other matters of the people. Lakshya, UN clause, simple. VK Kush, no. Not Lok Sabha election, not local body elections. Local body elections, state government will decide. Are you clear? Yes, Pooja. Okay. That's it. Done. Can a case against foreign national? Yes, it can be filed. Terrorist matters will go to the lower court only. Why will they go to Supreme Court directly? Lower court. So we are done with the high courts also. Solve this question first and then we'll move further. Okay. Retirement from the office of permanent judge of high court cannot plead or act in any court. No, he can. He can plead or act in so many courts, except those courts where he has been a judge. Wrong. A is the right answer. Nagendran is a judge of Bombay High Court, becomes Supreme Court judge of Bombay. What is Supreme Court judge of Bombay? What is this? Pihu, sir, can PIL be filed in High Court or Supreme Court both? Lakshmi, madam, what are you doing? You are asking minimum age. What is minimum age of High Court judge? Is it mentioned anywhere? No. You asked me about the age of retirement. It is mentioned. I just showed you the article, right? Article 217 talks about the appointment and the qualification. Karthikeyan, yes, exclusive to High Court. Yes, that also Karthikeyan. Okay. Now, lastly, the subordinate courts. I'll just explain the structure of the subordinate courts and we'll end our discussion at this point today by explaining to you the structure of the subordinate courts. It's very, very easy, very, very simple. See, we have across the country in total 25,000 plus judges. In the country, you simply write 25,000 judges. That's it. Now, one very important point I'd like to also make is that at the lower court level, subordinate court level, the highest court in a district is the district and sessions court. This is the highest court of appeal. And the judge sitting here is called district and sessions judge. Now, at the lower court level, you have two bifurcations. One is the civil side The other is the criminal side. This is what is called sessions. So a sessions court is that court which only hears criminal cases. Now in the civil side you have the civil judge, also called district judge. Then you have the additional civil judge. In the criminal side, you have sessions judge, below him additional sessions judge. Now just to draw a bifurcation here, I'll tell you why. Below these people, at the civil side, you have subordinate judge. Senior division. At the criminal side, or here let's continue. Below them, you have the subordinate judge. Junior division. Below them, you have munsif. They take care of civil matters. At the session side, you must have heard of this person called Chief Judicial Magistrate. Below him, you have Judicial Magistrate, but we call him Additional Judicial Magistrate. And below him, we have somebody who is called Judicial Magistrate First Class. Now, all the people above here, they are called, or they are a part of higher judicial services. All these people. And all these people are a part of lower judicial services. And everybody here, all these people, they are collectively known by one common name, district judge. Like you are an IAS officer, you can be a secretary, you can be a district magistrate, you can be the principal secretary, you can be cabinet secretary. Everybody is collectively called an IAS officer. Munsif is a judge at the lower level who takes care of civil cases. All these people, they are appointed by the governor on the recommendation of the High Court with two qualifications. District judges are appointed by governor on the recommendation of High Court. Either you have to be an advocate or a pleader. Pleader is somebody who pleads in court. It's the same thing. Advocate, pleader, same thing in our country. Are we clear? Either you are an advocate or you should be an officer in the judicial service. So basically, via promotions. So somebody here can come here, can come here, can come here, can come here via promotions, or can come directly here, or directly here, or directly here if he has been a lawyer for 7 years. Clear? Now, the lowest judge at the subordinate court level is called magistrate cum civil judge. This person is not called a district judge. And for him or her, how is the appointment done? The State Public Service Commission, SPSC, in your state conducts the judicial examinations. The Judicial Service exam, and the High Court conducts interviews. That's it. Okay. One more point. In the lower court, you'll be surprised to know that the session side, these judges can actually award a death sentence also. They can give you a death sentence. Are we clear? The only point is that it can be executed only after High Court's approval. Whether you appeal or not, High Court's approval is required to execute a death sentence which has been given or awarded by a lower court, but lower courts have the power to award a death sentence. Done. This is the entire structure of the lower courts. VK Kush, district magistrate, is somebody who is a part of administration. I am discussing judiciary, sir. What are you asking, sir? Pooja, subordinate court and trial court are the same thing. Sandeep, consumer court is different. It is a specialized court. Pooja, sir, you have said president appoint high court, but in my state, governor appointed high court judge. Which state, Pooja? Which state? In Rajasthan, governor appointed high court judge. You please share that data with me. Yes, Kumari, that can be done. Lakshmi, judicial magistrate, first class. Fast Satyapal, retired judge of Supreme Court. What's the point? Manage the services. We have 25,000 people here who are being managed by the state resources. So of course, it's difficult. We are Shubha, go to Supreme Court. 110 should be okay. Tomorrow, PPTs, PYQ of 2023. There are 3 questions you can solve. One on the presiding officer, one on the parliamentary committees, and which one more? 2 questions. Okay, so solve those questions, and if any other question you can think you can solve, please solve that question also. Then editorials, then Yojana Kurukshetra, then for those preparing for 2024, monthly magazine is a must, right? Then political theory revision can go on. That's it. Done. Pihu, magistrate come civil judge. There is no cutoff that death sentence will not be executed until and unless the High Court approves it.